All right, this is the time set for oral argument in 1 CA CV170774. You et al. Versus Coles Property LLC. I won't go over the previous admonitions, counsel, that I gave you earlier for the earlier argument, but I will just remind Mr. Fish, if you do want to save some time for rebuttal, please keep that in mind and use our podium clock for that. And again, since we are taping this and it'll be posted to YouTube, please state your name and the party you represent in this matter as well. So with that, Mr. Fish, go ahead.
Good morning to the court and the honorable justices. Once again, I'm Trevor Fish.
We're only judges.
Yeah,
we appreciate the compliment.
It's in the same building. We're in the same building. So
go ahead.
Yeah, downstairs instead of upstairs. I represent Coles Properties. Trevor Fish, again, represent the appellant. I'll attempt to reserve a little bit more time for rebuttal this time around, but I'll go straight into the issues on appeal because we're familiar with the background facts of the case. Certainly the issues on appeal for this case is going to be the effect that the ruling in the prior lawsuit, the prior trial court matter, of what effect did that ruling have on the second case. The appellees argue that, hey, the first case is the red herring, the first case doesn't matter, we're only focusing on issues done in the second case. We're taking somewhat the converse argument, saying, well, the first case ruling severely handicapped the claims that we could make in the second go-around. And that's where, of course, we use the argument of due process that denied Coles Property the due process to fully argue their claims.
We'll respond to the argument that he made before, which is the trial court in the second case did not rely on the default judgment.
I read the record differently, and I recall much differently that the judge, Mraz, I blanked on her name.
Mraz, yeah.
Judge Mraz. She specifically says, one of the arguments were you can't act as an appellate court for another superior court judgment. That essentially that she can't overturn that judgment. She's bound by what that judgment was in the first case, first matter. And that's how I recall in reading the record that she gives full force and effect on what was a previous judgment, that her hands are tied by it. So because of that, and that's where we're handicapped and denied that due process. Where the part of the issues on appeal for this case is that the court also erred in the amount of the judgment, and I want to clarify that, and I think it's pointed out in the briefs. The only issue that we conceded before Judge Mraz at the trial court level was that there should be a first priority security interest granted to the appellees, but just for the amount of the payoff for the first mortgage. So we weren't saying, oh yeah, they're in front of us in all respects. It's just the amount, and that's where we weren't contradicting, that they should be granted judgment, but only for that $517,000 amount, the payoff amount. The rest, we certainly were arguing that the trial court shouldn't grant the full $1 million judgment, over $1 million judgment, because we had competing equitable mortgage claims that had not been resolved. And that's, if you go to counsel's own argument, saying that the default judgment doesn't affect Coles Properties' rights. So if we take that at face value, that the default judgment in the first case, it doesn't affect Coles Property rights, well, then we should have been allowed to go forward in the second trial court matter of litigating our rights, the competing equitable mortgage claims. If they actually do have a valid equitable mortgage, which again we argue in the first case they don't, but assuming that they do have an equitable mortgage, well, in the second case we should have been allowed to litigate who is prevailing, who has the superior equitable mortgage claim. And that's where we point out our funds actually went towards the purchase of the property, the actual purchase. Our funds actually went towards the actual improvement and fix up of the property. That's what should have been litigated in the second case and was not. We're stuck with the issues involving the actual legal title, the quitclaim deed. That's what was resolved in the first case, that our quitclaim deed that we inherited or got from Imagine Enterprises, that's resolved because of the lis pendens. Anyone that takes title to the property, of course, after lis pendens is recorded, they take it subject to the ongoing case, standing in the shoes of the previous owner. So that's what was resolved in the first case, not the equitable mortgage claims that are competing. Again, as cited in our brief, our client was not named as a party in that case, even after becoming aware of our competing claim.
To the extent that the first case, responding to his argument, didn't just rely on standing, you're stating, or you're asserting that yes, but that's only with respect to the lis pendens defeating our quitclaim deed.
Correct.
Okay.
Yeah, the only specific ruling was standing, but there was the reference made to that lis pendens. That it's kind of like, well, there's lis pendens, your quitclaim deed is subject to that. But we never even got to the next step of, that's why you should let us in this case, because the lis pendens, all the rights are going to be resolved with respect to the lis pendens quitclaim deed. So let us litigate that, but we weren't allowed to in the first case. But still, the issues of the equitable mortgage competing claims, those were not ruled on or addressed in the first case. And the law is that the parties who are individuals that are not named as parties to a judgment are not affected by that judgment. And that's where the appellees chose not to include my client in the first case, chose not to amend their complaint to add us as competing parties that are alleging a competing equitable mortgage claim. They did not do that. They went forward, got their default judgment, but it's a default judgment that we are not named in. And that's my argument that I was making before Judge Mraz at the second case, the second trial court, that we're not named in that first case. We're not named in that default judgment, so we should be allowed to argue our competing equitable mortgage claims.
And did she allow you to?
But she did not. The trial court did not.
Respond to his argument that you had the opportunity to provide competing evidence via summary judgment, and you just didn't weren't able to do so.
That wasn't done. There wasn't. We provided plenty of evidence. I don't recall the judge ever found that there was lacking sufficient evidence. We had affidavit attached to our motion for summary judgment, which is cited in our memorandum. Affidavit from our client, the copies of certified checks.
But by implication, if she granted summary judgment, she had to have found there was no contested issues of fact.
That's what she ruled on, but she didn't specifically say that the evidence appears more in favor of the appellees than my client. She didn't even get to that point. She felt bound by the prior court judgment, that it didn't allow her to do the analysis of the evidence. There was not a ruling on who has the superior equitable mortgage claim. That was not a specific ruling that Judge Mraz made. So I know appellees are trying to argue that was presented to the trial court in the second case, but it certainly was not. That wasn't even evidence that was considered by the trial court judge. That she found that she was held bound by this first judgment and that we couldn't bring these competing claims, that there just wasn't grounds for that. And that was also the basis for the dismissal of our counterclaims for quiet title and for the wrongful lis pendens, that those couldn't go forward because if we couldn't bring a claim at all against the property because of the first trial court judgment, then we couldn't bring those counterclaims as well. So that's what I referenced in my memorandum, that was also a reversible error, that we should have been allowed to present the quiet title claims. And if the judgment is set aside in the first case, it would allow us to go forward on the wrongful lis pendens in the second case. So that's where it's dependent on the first trial court judgment.
Can you respond to his merger argument?
Certainly. The merger, that comes into place with mortgages, with lien holders that hold different mortgages. We'll see that in foreclosure type cases. It's not, and then there's no case law dealing with something like this, that a quitclaim deed that's provided after a lis pendens, and that's what's important, it's provided after a lis pendens, so it's essentially defective title, that somehow merged with a prior existing equitable mortgage claim. There is no case law that is on point to that there's a merger of that. And that wouldn't happen because the legal title is subject to that lis pendens, so it can't be merged with the equitable mortgage. And even if there was merger, that's grounds, again, going to the first case where we should have been allowed to litigate that if there was merger, we step in his shoes, the Imagine Enterprises, and so we should have been able to make the arguments that he would make, and also Cole's property arguments. So
state that again. I mean, you're saying if you're really following the merger doctrine here and applying it, you should still have been able to attack, challenge, etc., the existence or amount of the equitable lien established by Song Hee.
correct, absolutely. So that's where we argue that there wasn't merger, but even if there was, that's even more grounds where we should have been allowed in the case. We should have been allowed to argue, to attack their equitable mortgage claims, the amounts, all of that.
Is there anything showing in the records thus far that gives the Song Hee equitable lien a date, like a specific date? Like, for example, your equitable lien was established as of fill in the blank, February of whatever year we were talking about here. I mean, is there been a date associated with that particular lien?
It is dated differently than when the actual funds were received.
I mean, here's another question, related question. Did that come out of the first lawsuit or the second?
No, never addressed in the first lawsuit. All of this came to light in the second lawsuit. And that's where we find out in the second lawsuit, and here's some of the dates. The Song Hee promissory note, it's allegedly dated February 10th, 2016. So allegedly that's 6 days before the purchase of the property. So that's when the note is supposedly dated. That's in their pleadings. It's unclear looking at the document, but it's supposed to be February 10th, 6 days before the closing. But then it comes out when we, request copies of actual documents, bank account statements, anything to prove when the funds actually were paid. Then it comes out, the funds weren't transmitted until the 24th, so February 24th, 2016, and February 25th, 2016, which is well after the February 16th date. So,
would you agree that if we're going to affirm on the first matter, there's really nothing for us to do on this matter?
Of course I wouldn't agree that. No, in this matter, it's the same arguments that I made before Judge Mraz, is that if you affirm on the first case, you still should find that my client should be allowed to argue the competing mortgages claim, that we weren't parties to that first case, that the default judgment doesn't affect us, and using their own argument, the default...
Since they didn't let you in, you shouldn't be bound by it.
We're not named as parties to that judgment. So we argue who has competing, not just if we have an equitable mortgage, but we should be allowed to establish and litigate who has the superior equitable mortgage. So that's what should happen in the second case, which I wouldn't argue that you do this, but if the first case is affirmed, that's what's presented in the second case.
And I'll ask your counterpart here in this, but if we reverse in the first case, do we have to reverse in this case?
It would, because then it invalidates what a second trial court decision is based on. That Judge Mraz based her decision on a proceeding. There's a way to have it done.
Or could we alternatively just
consolidate it?
Hold it in abeyance, basically a ruling on this case, and you then would go back, or not hold in abeyance, just say, I'm not sure what the right legal phrase I'm looking for is, but couldn't you, based upon the ruling in the first case, go back and file a motion to reconsider, change in law, basically, new facts, new evidence, to have the court reopen its decision in the second case?
In the second case, motion to reconsider. Yeah, that would be, and certainly there would be grounds for Judge Mraz to reconsider her decision because of the reversal. So that certainly could happen. I don't know if that's the best way of going about it, but there's a procedural way to do that. And that also brings up the issue of, because of the ruling in the second case, we can't, or strike that, because of the ruling that we're bound by in the first case, there's certain arguments that we can't make in the second case before Judge Mraz, and one of them I was bringing up, that it's a voidable judgment, that their pleadings were incorrect, that the money didn't actually go towards the purchase of the property. Therefore, that default judgment is void or voidable, which you can file a motion to set aside a void or voidable judgment. But we can't do that because the court already said we don't have standing to file any motions. So that's one of my arguments, is that that's the denial of due process, is there's a tax that I want to make in the second case that I can't because of the ruling in the first case, where the trial court says, well, that's already been ruled on, you don't have standing, you can't attack it. I'm bound, the trial court judge says, I'm bound in this second case by the previous ruling. I'm down to 5 minutes. I do want to save that for my rebuttal.
You want more than 30 seconds?
Yeah, this time around. Thank you.
Counsel.
Thank you again. It's Richard Hunley for the plaintiffs and appellees. This is a little different than the first one, a different level of review, because it's the judgment of judicial foreclosure arose from the granting of a motion for summary judgment, so your review is de novo to see if there was a triable issue of fact. Maybe Coles Properties didn't realize it then or now, but the case in which they were to litigate, whether they had a lien or not, and the priority was in this second case, the case we're talking about now. We filed our motion for summary judgment. We did not simply rely on the default judgment, although we reference it. We put on proof of the amounts, and we argued that our position, the lien's position, was superior to that of Coles Properties, and therefore, as a matter of law, we can foreclose. Coles Properties did not put on evidence to refute that. In the briefs and in the argument, they don't cite any evidence to show why their lien would be superior to our lien.
Well, let's go back to, did they establish a lien? Did Judge Morose recognize that they at least potentially have an equitable lien?
Yes, and the whole argument was that it was either junior to ours because of the recordation issue and the list pendants, or its equitable lien had merged into the legal title it got, that Coles Properties got, when it got the deed. Those issues were litigated and argued in the motion for summary judgment. Judge Moraz's ruling, it's an under advisement ruling, it's in the index at 38. She does not say, I'm finding for plaintiff because of the default judgment. She doesn't say anything like that. She doesn't mention the default judgment. She says, as to count one of plaintiff's complaint, judicial foreclosure of equitable mortgage, plaintiff Song Hee is entitled to a judicial foreclosure of the property located at 3331 North 62nd Street and is further entitled to an equitable mortgage in the amount of $1,045,000. That results purely from the evidence that was put on in the second case. What we put on was,
But doesn't it presume that there was an equitable mortgage, which is dependent upon the first case?
No, she says that we are entitled to an equitable mortgage. She is giving it to us again, and she's giving it to us in a different amount than was in the default judgment.
Why the difference in amount?
Because between the first case and the second case, plaintiff Song Hee paid off the first position loan of $518,000. And remember, defendants admit that we're entitled to an equitable mortgage of $518,000. Perhaps they're arguing the difference in the numbers, but we put on evidence in the summary judgment as to those amounts, and nobody rebutted them. The defendants questioned it, but we put on the bank statements. This shows the $160,000 that was paid by Song Hee. We had his declaration saying I paid it. We had his declaration saying I had to pay off the first as well. We put on that evidence, and there was nothing to rebut it.
I will confess that when I read the transcript, or looked at the transcript, I can't say that I read every word of it. It certainly seemed that Judge Moraz was of the opinion that she was bound by the prior proceeding. What is your best point to the transcript to say, no, she set that aside and actually ruled on the merits alone?
I think there is a point in the transcript where she says, where's the amounts? I says, well, it's the amount of the default judgment, but it's also the amounts that we've asserted in this motion for summary judgment plus the additional $500,000. I think there's more than just reference to default judgment there.
And maybe I'm relying on his recollection or what he said, but my recollection is that she does say at some point, well, I can't relitigate those amounts. We can't relitigate what happened in the prior proceeding. So that's what I'm a little confused by your assertion that, no, that wasn't what she relied on.
Well, she could have. Well, the 518.
Is he right that she said at some point, we can't relitigate what
I think she may have said something like that, but it's because the defendant didn't put on any evidence to say that you should relitigate it, to say that these amounts are wrong. They did nothing to dispute the loan amounts.
Okay.
So there was nothing before her to cast doubt on the amounts of the default judgment.
So Coles agreed that you have a valid lien, a valid equitable lien, but you're saying their only argument in the second trial or second lawsuit was that they have priority over yours.
No, they agreed that we had an equitable mortgage, an equitable lien, at least as to $518,000.
Yeah, and that's what I'm talking about. I'm talking about the large
priority issue.
Priority.
They
issue.
ignored the priority issue. We
They
showed
did not argue that their lien should have priority over yours.
the argument they made was this. Let's see. Their argument was that we put up our money before you did to buy this house.
Right.
Okay. That fails as a matter of law, which we went through in the motion for summary judgment, because it was an unrecorded equitable claim.
And yours was recorded?
Ours was based on a Liz pendants. It was all
going back to the default judgment.
Yes, which was affirmed in the second case, in effect. In the second case, so this is the way it works. One of you, I believe it was you, Judge Brown, that asked the date of the lien for the equitable mortgage. The date of the lien would be the date we recorded the judgment, which was sometime in January 2017.
Really? It wouldn't go back to the date that the funds
That's
were...
the date of the lien. Its effectiveness as to anybody who acquires an interest in the property goes back to September 30th, 2016. That's just as and against Coles Properties or anybody else who subsequently acquired an interest. Okay. So, our lien is effective September 30th. Coles Properties they don't have a deed of trust. They didn't record the joint venture agreement. The joint venture agreement doesn't say it's supposed to be recorded. They didn't record any kind of lien. They didn't file a lawsuit to impose a constructive trust. They've never done a Liz pendants. The only recording they ever did was when they received and recorded the deed on December 6, 2016. Ours was before theirs. So any interest Coles Property has in this property was subject to our claims for an equitable mortgage, which were litigated in the first case and then again in the second case and upheld. So they are junior to our lien. So Coles Properties certainly has a lien to the property. They certainly have an interest in the property because ultimately they were the owner, but it is junior to our lien. So that when the property sold, our lien gets paid. Any extra would go to Coles Properties. Also under the statute, Coles Properties had the right to redeem. They could step up and pay whatever was owed to our client to satisfy that lien. They have those rights of redemption or reinstatement. The second issue, which was litigated as part of the motion for summary judgment, was the merger issue. So our position was this unrecorded equitable interest doesn't trump our claim because of the Liz pendant statute and because of ARS section 33411 and 412, which talks about unrecorded interest. Even if you did have some kind of assertable equitable mortgage, it merged into your title when you got full title to the property in December 2016. You cannot both.
Does that presume the validity of the Liz pendants, though?
It does not do
Your
what?
whole argument, doesn't it presume the validity of the Liz pendants, which is again contingent upon the validity of the first case?
Well, the Liz pendants is just giving notice of a claim. It presumes the success of the equitable claim.
And challenge the Liz pendants in the first case, that could.
No, they do it in the second case. If in the second case they put on evidence to create a tribal issue of fact, the case would have gone on, we couldn't sell the property. If ultimately they showed that, no, you were not entitled to an equitable mortgage, therefore you can't foreclose it, then done. Liz pendants just give notice of something that's going on in the courts. That resulted in a default judgment. That resulted in the judgment, the complaint to foreclose judicially. So it passes down through. They could have, in the second case, trumped the equitable mortgage, but they have no evidence. They still have not cited any evidence here. So that second issue I was getting to was the merger. And again, I said this earlier this morning. You cannot both hold equitable and legal title to your own house. Whether this is an equitable mortgage or a constructive trust, The argument is some third party owns title, but they're holding it for my benefit because of something that took place, because I paid off a debt, because I've been defrauded, or something like that. So even though the title's in the name of Joe Blow, I, Richard Hunley, have an equitable claim on the property. When I get the property, my equitable claim goes away. I now own the property. I can't enforce by judicial foreclosure my own property to satisfy my equitable claim in my own property. That just makes absolutely no sense. And that's not procedurally how it would work. So whether you look at the priority of the liens determined by the recordations or the merger argument, Coles Properties claims either failed completely or was junior to my clients, and Judge Meraz correctly granted the motion on the judicial foreclosure count. I have not looked at Coles Properties' counterclaim in that case lately. It did not direct, it did not challenge, it did not seek a judicial determination of the validity of our equitable mortgage or constructive trust. It did not seek to assert a constructive trust against us.
Are you talking about the 33-420 claims? Is that what you're
Yeah. The only claims that they directed...
I'll ask him about this, but I don't believe they cross it, or I don't believe that their notice of appeal, I'm sorry, I don't believe we have jurisdiction over those claims, even if they were brought up. Is that...
The counterclaims that were dismissed?
Yes.
Okay, well, that wasn't the point I was getting to. Okay. But my point was, the claims he's arguing that they could bring, they didn't bring them. They still haven't brought them. They did not bring a claim against us asking for declaratory relief, saying the equitable mortgage is unfounded. They didn't bring a claim saying that our Coles Properties equitable claim is superior to yours. So they're arguing claims they never brought. The only claims in the counterclaim brought against my clients was the 233-420 claims. One quiet title saying that we have no interest in the property, which is clearly wrong because they admit we at least have an equitable claim for $500,000. And the second, that our lis pendens was filed in bad faith, which is clearly wrong because all our lis pendens did was give notice of a lawsuit that had a constructive trust claim.
Let's say, that for argument's sake, let's say that your equitable lien turns out to be 0. Is your notice of lis pendens still valid?
Our notice of pendens is valid. It's giving notice of a claim where you were
attorneys,
unsuccessful.
Don't attorneys always take a little bit of risk by filing a notice of pendens if you're not ultimately successful?
No.
In
the law is...
what does the law say? It says if you file a groundless document. I mean, I'm just saying if it turned out, but you're saying there's no way it could be groundless here.
Well...
And I don't necessarily disagree with you. I'm just saying...
No, I understand the question.
I mean, it's theoretically possible.
A lis pendens is not sanctionable under 33-420 just because you lost the case. The other side would have to show that your claim was groundless or brought in bad faith.
To be something more than that.
Yeah. Otherwise, it would not function. The courts could not function with the lis pendens statute.
Yeah, in all your research on this case, and you understand it obviously in a lot more depth than I do, but did you come across any case that imposed an equitable lien based upon the language of a promissory note? I mean, I'm not talking about, like where you have deeds that were, not properly notarized, or the acknowledgement wasn't done correctly. Something happened with the deed of trust. It got fouled up. I'm talking about a pure note, and then that translates to an equitable
Off the top of my head, yes, but I couldn't tell you whether it was a reported opinion or just a memo decision or something like that.
Okay.
But I'm glad you brought that up because I want to address that. The argument that our equitable mortgage was inappropriate because there's no specificity, in effect, identifying the property in the note. That's really the argument. First of all, that wasn't raised at the trial court level, so I think that's waived. Secondly, the note says that the plaintiffs are to get a priority secured interest in all a borrower's property. Okay, well, the borrower's only real property. But more importantly, I think this is a distinction without a difference. If it's not an equitable mortgage, it's a constructive trust that was also used in the default judgment. And both an equitable mortgage and constructive trust are enforced the same way through judicial sale through ARS 33-725.
The note referenced both tangible and intangible property, so your argument, well, this is their only real property that had to be what it refers to, that's not necessarily accurate.
Well, it's certainly not specific. It certainly could refer to other things.
It could have attached bank accounts, cars.
It could have. It could have.
Whatever.
It could have. This does not have the specificity that you may normally see on an equitable mortgage. Like if it said, this note's giving you a security interest in this property on 62nd Street. It doesn't do that. It's a little vaguer than that. But my point is, they didn't raise it at the trial court level. And again, whether you call it an equitable mortgage or the alternative, a constructive trust, which would result if it's not particular enough, it's the same end game. It's the same type of lien and the same enforcement mechanism. So, without running the risk of repeating myself, I will stop unless you have some more questions. Okay, well, thank you very much.
Thank you, counsel.
Thank you. And thank you for allowing us to do these two cases in one day. That was a very good idea.
I wanted to address, I think it was Judge Brown that asked about case law referencing promissory notes and whether or not a promissory note such as this actually equates to an equitable lien. And I searched the cases and I couldn't find anything that specifically dealt with a promissory note that's unsecured, that doesn't identify a particular piece of property, that it actually created the equitable lien. There were some, and I cited some of those cases about that it said it was specific loan for property, and it references all of that property that the loan was for. Some of those that were old cases got in, but there isn't anything that specifically dealt with something like this, the promissory note language.
But what about Mr. Hundley's argument that doesn't really matter because they could still impose a constructive trust? I mean, because of the fraud against everything that he owned, or Imagine, or the.
And that's where you get the difference between the constructive trust, the equitable lien. That my argument has always been that this wasn't actually perfected lien against the property. That it's, again, it's not recorded. It doesn't identify the property.
But a court can impose a constructive trust as a remedy, correct?
Correct. The court can do that. But that's where even the lis pendens, though, isn't necessarily based on a constructive trust claim. Lis pendens are always based on equitable mortgage claims, that you have some legal title to that property. Otherwise, if you make a claim of fraud, someone makes a claim of fraud, they'll start recording lis pendens, in all the counties that somebody could own property and say, hey, I've been a victim of fraud, so I'm claiming an interest in all of the property whatsoever. That's not the best practice, and that's certainly not what's done. There is an issue of recording the lis pendens because you actually do have to have a valid claim in the title to that property. The promissory notes, and I'll tell you that it's getting to be a standard form such as this, where it says right in there, this is secured by first priority interest against any and all tangible property. I mean, that's getting to be just a boilerplate standard term in there, and that's where I've argued, and it's argued in the previous case, that that's not valid, that doesn't create an actual secured interest.
So are you arguing then now that there is a difference between the equitable lien and the constructive trust? Because if it was a constructive trust would be the ultimate remedy, it was improper to file, the lis pendens would be improper.
Correct.
What about Mr. Hundley's argument that you didn't make the argument for Judge Meraz that your mortgage had priority over the appellees at summary judgment?
We absolutely did. I mean, I have that in my motion, my response to their motion, my cross motion, the declaration by our client talking about, and not only did I make that argument, but I pointed out, that the first judgment is voidable, that it's not even based on actual true allegations, that they claim in the first case that the money went towards the purchase of the property. And, so that's pointed out, and that's where it became an issue of when did this money get paid, and that was discussed or brought up before Judge Meraz, is that the money didn't actually go towards the purchase of the property. Unlike my clients did go towards the purchase of the property. So we attacked their, the actual basis for their judgment, but that's where the Judge Meraz, she indicated that an attack on their promissory note is basically an attack on the default judgment. She couldn't set aside a default judgment in a previous case where she couldn't act as the appellate judge for another Superior Court matter. So we couldn't make those attacks on that default judgment. And it's an issue that's before the court because we did say, or we did argue, that the default judgment wasn't valid because of all these issues. And really, it's an issue that was preserved on appeal for the first case also, because we brought up that we didn't get a chance to make the claim that it's avoidable judgment because we didn't have standing. So we did. I mean, it's, again, I have a different recollection of the record, but I know what was put in our response summary judgment, response to their summary judgment with the affidavits, the declarations, where we point out the actual amounts that were paid to the property. I mean, I don't know what more arguments I could have made, but to say ours is superior because of this, and that's what I did, is I listed all the amounts that our client put into the property. So certainly it was an argument that ours was superior. I'm out of time unless there's any further questions. But
I think we're good. Thank you, counsel.
Can I address just one point?
Sure, go ahead.
Counsel said that a notice of lis pendens or a constructive trust would not give rise to a notice of lis pendens. That is patently false. The lis pendens statute is 12-1191, subsection A, authorizes the recording of the lis pendens in an action affecting title to real property. Quote, in an action affecting title to real property. That's any action, mechanics lien, equitable mortgage, and a constructive trust. If you're asking that property be deemed to be held in constructive trust for your benefit, that's an action affecting title to real property. So, thank you very much.
All right. I believe out of fairness to appellant, do you want to respond to that at all?
I, of course, am going to disagree with that. Again, if an action affecting title to real property is different than saying, hey, I'm owed money and I want to be paid out of the judgment debtor's property. And that's certainly a difference. It's certainly a difference. If you're making an equitable title claim, then at least you can say that that is an action that's going to be affecting title. But when you're saying constructive trust, that, you know, I want the court to hold all of the property in trust, that's not the same as doing the lis pendens.
Thank you. Thank you, counsel, for your briefs and your oral argument today. We do appreciate it. We'll take the matter under advisement and we'll issue our order in due course. Thank you.